Attorney General.
Thank you very much, Madam President, and thank you to, in particular, the Minister of Trade and Industry, who has just preceded me, who is the line minister for this very important industry. And thank you to my colleagues on the independent bench of this very proud House, the Senate of Trinidad and Tobago. I listened with interest and I was encouraged, and I wish to go on record to say as much, by the very forthright, well thought out, researched contributions which came from every member of the independent bench who contributed to this debate today. And I would do a disservice to my contribution if I did not spend a little time in my wind-up addressing the concerns and the contributions which they have shared with us in order to give them the absolute assurance that this government has welcomed all of their contributions. I have welcomed all of their contributions. And for what I have described already as a work in progress, we are looking forward to continuing to build out the suggestions that have been made in what will be a continuing work in progress. I have given the undertaking to the independent senators and to this House that in due course I would be returning to this House, to the Parliament, to improve the legislation which we are asking the Parliament, the House today, this chamber, to pass, and of course looking forward to the contributions which have already been made by the bench, the independent bench, to building out the very important regulation system that the Minister of Trade and Industry is already hard at work on. I'd like to give the independent senators the assurance that the environment is a very important part of the lens through which this legislation is going to be enacted if it is passed into law today and to be implemented. You will see when you read the act, and now that I can proudly say that I'm slightly more adept at computer use than I may have been a couple months ago, while we were speaking today, I wrote in one word on the PDF copy of the amended bill which came to us today from the Senate. The one word I wrote in on that PDF copy was prescribed. The word prescribed appeared 33 times throughout the course of the bill that we are debating today, and it is there 33 times to emphasize how important will be the regulations, because every time you see prescribed, it means there are going to be regulations to address what the bill does not speak to in explicit language, but which is within the contemplation of the holistic approach to the law that is going to be passed and built out to regulate this industry. Environment is already referred to in sections 2 and 4. We have authorized officers include members of the environmental team of the Environmental Management Authority. Public health considerations. Senator Richards expressed his concerns about public health considerations. Public health officers are already among the persons who will be the authorized officers to ensure that when they go to inspect the scrap metal sites, the public health is being secured, the public health is being protected. And in the regulations which we will build out, we will be consulting actively with the public health ministries and departments to ensure that we put together a holistic scheme for regulating this industry. The green and sustainable recycling policy, which Senator Vera spoke to. It is true that the bill is to that extent because we are urgently about managing the current problem that we are seeking to manage. And it is true to that extent that the bill is in its present incarnation one-dimensional as a licensing regime, but that does not mean that it is not part of the whole of government approach, which we as a government are seeking to apply. On Wednesday of this week, and I believe Senator T.A mentioned it, on Wednesday of this week, the motion had been put about beverage container legislation, and the Minister of Public Utilities responded to that question. And in responding to that question, relevant to what we are talking about today and relevant to the question that was raised validly by Senator Vera, the Minister of Public Utilities referred to the fact that there is in hand right now a draft national waste recycling policy for Trinidad and Tobago 2022. It is dated June 2022. And with your permission, Madam Speaker, I would just read from two parts of the introductory part of that draft brief, I beg your pardon. Policy objective. The policy objectives expanded on these stated in the 2015 earlier incarnation are to A, strengthen national policy and strategy to develop a sustainable national recycling system that supports the circular economy to which Senator Vera spoke. Paragraph 4.0, overarching principles. The overarching principles of the policy are consistent with those of, speaking to Senator Richards, those of the National Integrated Solid Waste Resource Management and with the National Environmental Policy. These principles will guide the implementation of the wider plans for recycling in Trinidad and Tobago. These are concerns that were raised by Senator Richards, raised by Senator Vera, raised by Senator T.A. They are going to be part of the whole of government approach, which will be married to the implementation of this legislation when it is passed into law and it is built out with the regulatory system. Madam President, the Honourable Senator Drayton spoke about the trade-based money laundering and terrorist financing regulations that have to be built out. We already have, and he has recognized, references in the legislation to the AML, CFT, and that entire regime that will fall under the FIUTT and the POCA legislative scheme. There is going to be risk-based questionnaire systems that will be built out. There is consultation that is going to take place with the FIUTT of Trinidad and Tobago to marry with the passage of this legislation a sustainable environment to protect the country and its economic integrity from terrorist financing and anti-money laundering activities, which are very much part of the scheme of this legislation. And we have that in one of the amendments that we passed in the House on Wednesday. We have the addition of the schedule that lists the Scrap Dealing Association, Scrap Dealing Business, as a listed business under the POCA legislation. So that too is being looked at, and that too is going to be part of the systemic and holistic approach that this legislation contemplates. Madam President, Senator Richards had also raised the question, you asked me to address it and I will address it, the question of a waiver of property rights, because there is in the legislation, the bill that we are seeking to pass into legislation, the fact that to get a license under the Act, under the bill, you have to consent to your premises being susceptible to entry and inspection. And in the short term, where we are building out select provisions of the deeming provisions that have been brought into play by the new Section 39, there is a scheduled form that by which someone who will want to continue to carry on the business of scrap dealing in the current licensing regime that exists under the current law, which is going to be repealed by this bill, you see that there is a schedule by which those persons will have to opt voluntarily, and this is very important for the constitutionality of the point, they will have to opt voluntarily to agree that their premises will be liable to be searched and examined by consent. And that brings me, Madam President, to address a concern which I know some of the independent senators have been onto, and I know will be a false alarm, if I may say that respectfully, a false alarm which the opposition, United National Congress senators, will wish to sound for the population. No part of this bill, no part of this intended legislation is going to infringe anyone's rights. And I'm happy to be able to read into the record, with your permission, Madam President, the language of the Judicial Committee of the Privy Council in the Suraj case, that case that came out of our public health pandemic over the last 2 years, when there was a challenge to the regulations that had been brought into being in Trinidad and Tobago in order to put the society under manners for public health safety. And there was a challenge, as we all know, to the constitutionality of those regulations. And in the Privy Council, in the High Court, our High Court, Justice Budu Singh, said there was no violation of constitutionality. In the Court of Appeal, our Court of Appeal said there was no violation of constitutionality. And it went to the Privy Council, and the Privy Council agreed with our High Court and our Court of Appeal in a judgment which is now the guiding and binding law that addresses the question of the constitutionality of the legislation we are asking to pass today on the simple basis of a simple majority. This is what was quoted from the earlier Trinidad and Tobago case of Surat, at paragraph 54 of the Suraj judgment. The Privy Council quoted from Baroness Hale. It cannot be the case that every act of Parliament which infringes in any way upon the rights protected in sections 4 and 5 of the Constitution of Trinidad and Tobago is for that reason alone unconstitutional. Legislation frequently affects rights such as freedom of thought and expression and the enjoyment of property. This is to Senator Richards' concern. These are both qualified rights which may be limited either by general legislation or, in the particular case, provided, and I stress this, that the limitation pursues a legitimate aim and is proportionate to it. I end my quote there. Pause. Let us think back to what was taking place in this country in the early part of this year, which forced the government to shut down the entire industry for the limited time it has had to be shut down. In my opening, I read the record of the significant millions of dollars that were being literally ripped out of the ground. I spoke to, and other speakers, other contributors have spoken to, the fear of persons living in their house, looking through their windows and seeing their gates being pulled out of the ground, even while they try to shout and say, no, don't do it, and are being threatened, stay in your house, don't come out, I'm going with your gate. That is the proportionate balance that this legislation has to be measured in the context of when we ask ourselves the question, is there anything unconstitutional about asking someone to agree, if you are going to engage in this business, you will agree for reasonable powers of inspection to be exercised over your property while you are allowed to engage in the legitimate business of scrap dealing. And the Privy Council continued at paragraph 68. A very large part of ordinary legislation passed by Parliament for good reason of the public interest must inevitably interfere with or operate as restrictions on those rights. In the board's view, it was not plausible to suppose that the framers of the 1962 Constitution and the current Constitution of Trinidad and Tobago intended to disable Parliament from taking ordinary legislative action in the public interest. The natural solution to accommodate the inevitable friction which always exists between individual fundamental rights and democratic decision-making in a constitutional liberal democracy like Trinidad and Tobago, said the Privy Council, is that conventionally adopted so often in such states, namely to require that interference with rights should be permitted in the public interest, but only if the interference is proportionate to a legitimate aim. And I make the point, Madam President, that the purpose of this legislation, as set out in its preamble and throughout its 42 clauses, is the legitimate aim of bringing under control the rampant criminality of a few in order to permit the larger sector of the community who wish to engage in the business of scrap dealing to earn a livelihood, to permit that larger percentage of the population to be able to go about earning an honest day's living and earning an honest day to put bread on the table and to send their children to school. So there is no question of an interference with rights, fundamental or otherwise. The Honourable Senator Lakshmidiyal raised a bit of well, let me withdraw what I was about to say. Senator Lakshmidiyal addressed Section 33 of the legislation, the draft bill, and she has sought to suggest that by Section 33, somehow or the other, there is some abuse that is going to take place by reason of the fact that a permanent secretary is being given the power to administer the administrative fines. She went as far as to refer to Section 86 of the Gambling and Betting Act, referring to that body incorporated under that act, which is a body corporate, which may, with the consent of the DPP, offer a person a chance to pay an administrative fine. Well, our clause 33 is actually modeled, may it please you, Madam President, off of Section 33, or off of the Gambling and Betting Commission Act. And all that has been changed is that instead of the Gambling Commission, there is the permanent secretary. There is an exact correlation and similarity between the commission and the permanent secretary in the same way that under Section 244 of the Customs Act, which I read, where a person admits that he has committed an offense against the custom laws and requests in writing that the offense be dealt with by the Comptroller of Customs, the Comptroller may, subject to the approval of the Minister, impose a fine, penalty, and forfeiture, but not including imprisonment and not exceeding that prescribed for the offense, or mitigate or remit any fine or penalty or restore anything seized under the customs laws. Well, the Comptroller, like the permanent secretary, is a senior public officer, and there is nothing unconstitutional or unlawful about the exercise of powers by the Comptroller of Customs under Section 244, in exactly the same way that there is nothing unlawful about the exercise by the permanent secretary of powers conferred on him or her pursuant to the provisions of Clause 33 when this bill is passed into law. The permanent secretary is appointed by the Public Service Commission and would be advised by the legal unit of that ministry as to whether or not there is good reason to believe that a prescribed summary offense has been committed. Summary offenses which attract an administrative fine are generally straightforward. Strict liability offenses, such as a failure to meet a deadline to file a document. The licensee does not have to pay the administrative fine to discharge liability for the offense. If the licensee does not want to pay the administrative fine, then the permanent secretary will refer the matter to the police. So it's not a judicial exercise of any activity that the permanent secretary is doing. Permanent secretaries throughout our ministries take responsibility for many matters on a daily basis on the advice of the legal advisors in their ministry. There's nothing unusual, nothing unlawful with requiring a public officer, the most senior public officer in the ministry, the permanent secretary, to be responsible for that which he or she is appointed to discharge, the administration of the system within the scrap dealer industry. The local legislation, Madam President, from which we took succor and support for prescribing the consent which is required in the case of allowing entry onto the premises, comes from local legislation in our jurisdiction. The very Gambling and Betting and Control Act to which Senator Lashmedia referred, the Trinidad and Tobago Special Economic Zones Act, and the Cannabis Control Act. It is reasonable in circumstances such as is prescribed there and proportionate for a licensee to consent to the entry for purposes of verifying compliance with enforcement procedures. It is reasonable and proportionate for licensees to be inspected during working hours. The requirement for consent is in keeping with and consistent with the legitimate aim of ensuring compliance and is proportionate to that aim. It meets the requirements of the local cases out of this jurisdiction from the Privy Council of Surat and Suraj and should not be regarded as an infringement of fundamental rights. The legal concept of waiving your rights voluntarily in order to participate in an activity is well established in law. Madam President, the government of the country has the constitutional authority to govern this country, and permanent secretaries like controllers of accounts, controller of customs, are the ones to discharge the functions on behalf of the government for purposes of ensuring that the country is well run. The rules of natural justice and the laws against the abuse of discretion of ministers will apply equally to the exercise of the function of the permanent secretary. And there is provision in the Act for a decision by a licensee if that licensee thinks they have been treated either unfairly or capriciously, or that the reasons have not been properly given which satisfy them, to go to the court of law. And there is a concept that we happily overlook when it suits our purposes in this country, particularly when it comes into the political arena. A presumption of regularity. The presumption is not that public officers will be capricious. The presumption is that they will not be capricious. They will discharge their duties and their responsibilities like the responsible persons that they are. The consent of the DPP is not necessary for the administration of an administrative fine system. That's a red herring, if I may say so with respect. So let's put that to bed as well. There is the other point, Madam President, and I once again return gratefully to the concerns that have legitimately been placed by the independent senators. That is to say, the use of reasonable force. Is that something that is excessive? Well, the Criminal Law Act of this country, from which we have borrowed, tells us in no uncertain terms, Madam President, Section 4 of the Criminal Law Act provides a person, and we're not now even speaking about a police officer, a person may use such force as is reasonable in the circumstances in the prevention of crime or in effecting or assisting in the lawful arrest of offenders or suspected offenders or of persons unlawfully at large. So the precedent is not only already there, but it is already the law of this country that persons may use reasonable force as is appropriate. So when the authorized officers, whether it be the police officer, whether it be the supplemental police officer, or the public health inspector, or the environmental agent out of the Environmental Management Agency, goes in to inspect and is being prevented from entering and or I would dare say that on good advice, the public health inspector and the environmental management officer would be probably advised to say, well, just report it to the police. But they can, as ordinary people, under the Criminal Law Act, not under the bill that we are debating today, use reasonable force in appropriate circumstances for the prevention of a crime. And under the act that we are asking this House to pass today, the bill, it will be an offense to prevent the lawful discharge of officers endowed with power under the bill from discharging their functions. Madam President, one of the, and I must refer to it because it is not a point that I should leave as uncontradicted, but I would have thought that it didn't need to be raised because I spoke of it in the other house. One of the points that was raised by Senator Mark was to suggest that the national consultation exercises, which I spoke of in my opening today, was a mere figment of my imagination. Well, let me say it for the second time. I said it on Wednesday, and I will say it again, Madam President. We met 3 times with the national stakeholders in this industry, and we got a multiplicity, I gave the numbers, I'm not going to repeat them, of responses from the stakeholders. But what I will do now is I will read some of the responses that we got. So they responded, they corresponded with the Ministry of the Attorney General, and they proposed the removing of the licensing system from the Magistrates Court to the Ministry of Trade and Industry. That's what we've done in this bill. They propose that licenses should be annual. That's what we've done in this bill. They propose that there should be inspection of the loading of scrap metal for export at the scrap metal site. That's what we've done in this bill. They propose that the Minister of Trade and Industry should have the power to vary or revoke a license. That's what we've done in this bill. They propose that there should be imposed in the bill a duty to keep records by the collectors and the dealers. We have done that in this bill. They propose that there should be a power of entry and inspection to certified officers. We've done that through the authorized officers and the inspector of scrap metal. They propose the establishment of a database for the industry. We have done that, public and private databases. They propose the identification of motor vehicles being used to collect scrap metal. We've done that, and we've said that the motor vehicles must have a license prominently displayed. They propose that there should be an increase in penalties. We've done that in this bill. They propose that there should be a practice for the majority of scrap metal collectors and dealers to present identification at the point of collection or sale of scrap metal. That's what we've done in this bill. They gave and articulated strong support for the law to require collectors and dealers to present identification and contact details of the nature laid out in this bill when buying and selling scrap metal. They propose that the clear majority of collectors and dealers be requested to record customer contact information. And it goes on. I can continue, Madam, but I will pause there to address one other question which was raised by Senator Mark in his suggestion that I am here engaging this august chamber by the measure of the figment of my imagination. We received responses. I have the list here, Madam Speaker, Madam President. We received responses and we corresponded and engaged 229 collectors on this bit of paper. And their names are all here. I am not going to read their names into the record. I respect their privacy, but I have them all here. We received correspondence from an input of the nature that I've just read out from 17 scrap metal collectors. And I have the names here. Their corporate names. I'll give just a couple examples. West India Company Limited, Rudy Scrap, Nasaja Contractors Limited, Haku Scrap Dealer, ABC Scrap Solution Limited. We received contributions from all of these persons, 229 collectors and 17 dealers. And it is on the basis of that that we worked with the Law Reform Commission and put together the bill and the policy document that has come to this House. So, Madam President, without belaboring the point, we are here today, this government, as a responsible government that wishes to promote the industry and wishes to protect the legitimate persons engaged in industry. We are here today to ask this bill, this House, this august House, to pass this bill so that we can get about the business of proclaiming those bits of it which will allow us to reopen the industry by the end of the year so that legitimate, bona fide, small families can have some bread on their plate and send their children to school in January 2023. And I beg to move.
Honourable Senators, the question is that a bill entitled An Act to Create Measures to Regulate the Business of Dealing in Scrap Metals and for Other Related Matters be now read a second time. Those in favour say aye. Those against say no. I think the ayes have it.